Quick note before we start today's show, I wanted to remind you guys to check out the System is Down podcast hosted by Dan Smolt, aka Dan Smots. The podcast is all about talking about things that generally make people a little bit uncomfortable: religion, politics, conspiracy. Bottom line is Dan will talk to absolutely anyone about absolutely anything. Nothing is off the table. Recently, Dan ran into a little bit of trouble with the Facebook police. He's had his accounts banned from Facebook, his personal account, his business page accounts, his podcast accounts, his wife's account. Everything has been scrubbed from the Facebook world. So if you could, please support the System is Down podcast. Dan will be coming on Finding Freedom next week to talk more about what has happened and how he has reacted to the Facebook banning. The System is Down podcast. Check it out.
We are born free, and we will die free. The time in between, though, that's complicated. In that time, governments, institutions, and our egos will limit our ability to find true freedom in this life. These are real stories of real people overcoming the odds, persevering in justice, and unlocking their potential. Welcome to Finding Freedom. Here's your host, John Odermatt.
Welcome back to the second edition of Finding Freedom here on the Lions of Liberty podcast. If you missed last week's show, you might be wondering, why, John, are you talking on a Thursday and what happened to Felony Friday? Well, tune into last week's show, episode FF262. I believe it was titled Welcome to Finding Freedom. And I talk about the reason I changed the scope of this podcast and what I'll be focusing on going forward. So go back, check that out if you missed it, or if you don't want to, don't. I don't really care. Today's episode, awesome, incredible episode, great guest. Going to be talking with a guy in the state of Arizona who is suing the mayor of the city of Flagstaff in the Arizona Supreme Court. Incredible case. We're going to be going through this case, the argument for it, with a fine-tooth comb. It's very, very well researched, and in speaking with Joseph McGhee, this is my guest for today, who I'll introduce shortly, he is very confident in the prospects here. So keep an eye on this one. Nobody else is talking about this in any media out there, so I was very excited to get to speak with Joseph McGhee today. I do want to ease your minds. If you listen to Joe's audio at first, you might think, oh man, this audio is a little bit rough. I did my best cleaning it up, but it's only his first answer that has that audio. We corrected the issue after that first answer. The rest of the interview, which is an hour long or more, is phenomenal audio and obviously great content. And let's get into it. My guest today on Finding Freedom is Joseph McGhee. Joseph is an Arizona resident, and he has filed a lawsuit in Arizona, the Supreme Court, over mask mandates. He's suing the governor and as well as the mayor of the city of Flagstaff. We'll get all into the details there. It's a meaty lawsuit. Joseph, welcome to Felony Friday.
Thank you. Thanks for having me.
Just said the wrong show. I just changed the name of my show. Welcome to Finding Freedom. Wow.
That works too. Thanks for having me.
But that's a good thing to kind of kick off. One of the main reasons that I changed the format and the name of my show, previously, I was almost entirely focused on the criminal justice system and sharing stories of particularly felons, people who had been through the system. But I wanted to zoom out a little bit in order to look at larger issues, and especially in today's crazy times with lockdowns and mandates and everything that's going on, be able to talk to people about a wide variety of different things. And that's why I was happy when your story was brought to my attention with, someone that is actually taking action to do the best they can to not only get freedom back, which has been infringed upon by the government, to get that back for themselves, but also for the community. So, Joseph, I think a good place to start is, let's just start general background with your thoughts on coronavirus. It's been almost about a year. when this all broke, February, March last year, when we realized, things were getting crazy, where were you at back then? What was your thought process back then?
Well, I had actually been researching coronavirus since around January. We had known that it was in China in December and January. Published studies started coming out of China late January, early February. So that's where I went directly. I'm not at all interested in someone's expert opinion. I'm not interested in what public health authorities have to say, per se. I'm interested in what does the science say. And the science, that word gets thrown around a lot these days. Trust the science, listen to the science. But the science is not someone's opinion. It's not some expert on TV telling you what you should do, what you should believe. The science is peer-reviewed, published studies. It's actual research that has taken place. Where the scientific method has been utilized. So when people say trust the science, listen to the science, unless something is a result of the application of the scientific method, it's not science. It's speculation. It's someone's opinion, or it's anecdotal. So I started reading these studies, very early on, and I quickly came to realize that one, coronavirus is a serious virus. It's not made up. It's not, it's an actual virus, and it is dangerous. But very early on, what I found from the research was that this danger really only exists for certain groups of individuals. Those are older adults, and especially older adults with specific chronic health conditions, diabetes, kidney disease, obesity, COPD, things of that nature. And so looking at the original research that came out of China, it became very quickly apparent. It became apparent to me very quickly that this was not something that most people had to worry about. The worst fatality rates that were coming out of China were about 3.4%. But those were overall fatality rates. So those were not, age adjusted. Those were not for specific groups. So when you look at the research, age adjusted and adjusted for, specific chronic health conditions, we're looking really at an infection fatality rate of less than 1%, which is not a public health emergency, as applied to the vast majority of people. And study after study after study, they conclude the same thing. Stanford put out a study, USC put out a study, UCLA with the public, LA County Public Health Fund. They'll put out studies, and all these studies, have basically confirmed that the infection fatality rate overall is in fact less than 0.5%, except, when we start looking at these groups that are at risk, these are the people with chronic health conditions, in which case the infection fatality rate can jump up to 13, 15% if you're talking about people over 75 with kidney disease. But, overall, looking at the science, reading the studies, which again is that's the only thing that I defer to is the actual published peer-reviewed studies. It's quickly apparent that this is not the threat to humanity that it's been portrayed as. It's just.
Yeah, so that's really where I fall too. This coronavirus does kill people, or I should say, COVID-19 does kill people, not SARS-CoV-2, which is the virus. But I think it's been largely blown out of proportion. There's a lot of false positives, and I wouldn't be surprised to see sort of the temperature turn down on coronavirus once we get into this next administration, when they all of a sudden figure out, wait a minute, we have all these false positives, and they adjust their numbers. But anyway, that's probably a different discussion. So let's talk about, and I mean, just to get this on the record, I think I'm correct here. You're not a lawyer, right?
No, I'm not a lawyer. I've never been to law school. Okay. I have no formal legal education.
Okay. Neither am I. I host a criminal justice podcast, but no law education. So you can do anything. And I've read your lawsuit. I mean, it's very, very detailed. We'll try to get to as much as we can. But so not being a lawyer, I don't know what else background you would have in the law. When did you decide to pursue the path of filing this lawsuit? And how did that come together for you?
Well, I had actually, and a point of clarification real quick. So the lawsuit is not actually against the governor of Arizona. He's just named as a real party in interest because I'm challenging his authority to issue an executive order allowing for mask mandates. So he's not actually a defendant or a respondent as it would be in this petition. It's just Mayor Paul Deasy is the mayor of Flagstaff and the city of Flagstaff. Mm-hmm. So with that in mind, March of this year, I sued the city of Flagstaff and the mayor at the time, as well as the Arizona governor, over the restaurant closures and the stay-at-home order. So that was a case that was filed in Superior Court. I brought it under 42 USC 1983, which is civil rights. The defendants removed the case to federal court. I filed a motion for a temporary injunction. We had a hearing on that May 8th in front of Judge Snow, who is the chief judge of the Arizona federal court. So that hearing progressed, and the injunction was denied. And so the stay-at-home order was expiring in 8 days. So I just went ahead and dismissed the lawsuit. But I was really trying to set precedent with that over the stay-at-home orders. I really saw sort of a dark cloud over freedom that was building with these stay-at-home orders, and with depriving people of the right to earn a living, closing businesses, forcing people to stay in their homes. None of that, in my opinion, is constitutional. None of it is lawful. The United States, for example, I would argue that, if the founders, if the framers of the Constitution had intended for safety to be more important than freedom, then the Fourth, Fifth, and Sixth Amendments would not exist. These are amendments that are directly contrary to what we would consider safety, but you tweeted that out a couple of days ago. I thought that was a great take. Thank you. So I dismissed that lawsuit. Stay-at-home order expired, and honestly, I had been expecting that the governor would lift the state of emergency. The city would rescind the mask orders, to have some sort of progress. And that just hasn't happened. So I actually began drafting this lawsuit on January 1st, the morning of January 1st, worked 14 to 16 hours at a time, then I would rest. Did all the research, all the writing and everything, got filed on January 6th. But it's very important for me to utilize the court system, as best as I can as a self-represented non-lawyer, to try and establish precedent, with regard to government powers during a state of emergency, during a public health emergency. Mm-hmm. And, this is not something that, is going to be won in a single case. It's going to be won through attrition. It's going to be small steps, small victories, getting precedent set, and eventually being able to hold to account government officials and government agencies for essentially depriving us of our constitutionally protected rights in the name of protecting us.
Mm-hmm. So just to lay out the case here to start to, so correct me if I'm wrong, but state of Arizona, the governor has not put in a mandatory mask mandate.
Correct.
Rather, it's that the individual municipalities or towns or whatever they are, they're able to do that on their own. Correct.
Correct. And yes and no. I mean, the governor of Arizona issued an executive order allowing municipalities to impose their own mask requirements. And so, no, there's no statewide mask mandate. And I believe that is intentional because it's not constitutional. Mm-hmm. And so now we have this piecemeal where some cities have it and some cities don't. But I mean, if you look at the mask orders, the mandates from the various cities and towns and counties, you'll see that they're all substantially the same. It's basically boilerplate as to these mask requirements and exemptions, et cetera, and enforcement.
So that's, I guess that'd be the reason why the lawsuit is targeting the mayor of Flagstaff rather than the governor. Correct.
Correct.
Okay, so just kind of take us through and lay out how you've built this case. What, I guess, starting with standing. How do you go about showing that you have standing for this case?
Well, standing is established because of the nature of the relief that I'm requesting. Basically, I'm requesting declaratory and injunctive relief. I'm requesting that the Arizona Supreme Court rule on the constitutionality and legality of not only the mask orders, but the authority under which the mask orders are issued. Not just the cities and counties, but the governor's authority to delegate the authority to issue mask orders to these cities and towns. So I have standing, under the Arizona Uniform Declaratory Judgments Act, because I'm a person whose rights are affected by a statute or a municipal ordinance. So, I mean, that's Arizona Revised Statute, Section 12-1832. So standing is implicit in the nature of the claims that I'm raising. I'm a resident of the city of Flagstaff, so I'm standing to raise that claim against the mayor. But even if I wasn't a resident, I would still have standing as long as I, conducted business in Flagstaff. As long as I was somehow reasonably subject to the mask mandate, I would still have standing to bring this case. So I'm not suing for damages. I'm not suing for money. I'm just suing to stop this.
Hey, everybody, taking a quick break here from the show. Wanted to remind you all to check out my man Tyler Colford, a.k.a. Crypto Man, and his new song, Free Ross. If you didn't hear my recent interview with Lynn Ulbricht, that was Felony Friday, episode 230. Interviewed Lynn Ulbricht, played Tyler's song, Free Ross. It's fantastic, phenomenal. Not just for the message of freeing Ross Ulbricht, but overall for changing the broken criminal justice system. All the proceeds from the Free Ross song, hashtag Free Ross by Crypto Man. You can find it on Spotify and Amazon Music. 100% of the proceeds from the song, hashtag Free Ross by Crypto Man, go towards freeing Ross Ulbricht. So please check it out.
These are perilous times when they ruin your lives over victimless crimes, and they sever your ties from your business, loved ones, and family. Why? New slave play, but they barely pay you. Don't care about work ethic or major.
Did you ever think about approaching, I don't know, a group or other individuals to join your case?
I found, when I filed my original lawsuit against the governor, back in March, I found a general unwillingness for people to become involved because they did not want to be seen as running contrary to public health and safety. So I approached a lot of organizations and a lot of different people. And while they offered me sort of, their quiet support in that, yeah, we hope you win, it was a matter of, well, we're not going to get involved in this because this is bad publicity for us. So I approached attorneys, I approached certain civil rights organizations, and nobody was interested. And with the controversy over masks that's going on right now, I just figured it was completely pointless for me to seek any help from any organizations or persons on this. It's just, I didn't see any way that anyone was reasonably going to want to get involved.
Yeah, I mean, it's a noble task going in on this alone. I give you much credit here. Somebody's
got to do it.
So what is the argument? Can you break it down for us? I know it's very thorough, so you can take it piece by piece so we can talk about it. But
Sure. I'll just so basically the argument in the petition is set forth under 4 sections. Section 1 argues so there's a religious exemption to these mask mandates that's essentially verbatim statewide. So all of the political subdivisions, what they're called under Arizona law, cities, counties, towns, they all have a religious exemption to the mask requirement. So the first argument that I've raised is that and all of the claims that I've raised are brought under the Arizona Constitution. I've not raised any claims under the U.S. Constitution, and that was deliberate. I don't want this going to federal court. This needs to stay in Arizona because federal courts are loath to rule on issues that essentially only pertain to states' rights, 10th Amendment. So keeping this out of federal court is really mandatory in this. So the first argument is that the religious exemption provision of the mask requirement violates 2 separate clauses of the Arizona Constitution, violates equal privileges and immunities clause, and it violates the local or special laws clause. And essentially what that means is that the Arizona equal privileges and immunities clause is much more stringent than the 14th Amendment. So it'd be the Arizona equivalent of the 14th Amendment, but the courts have repeatedly recognized this fact. So essentially, the religious exemption creates 2 separate classes of individuals. One class of individuals is required to follow this law under penalty of potential arrest and imprisonment, fine, criminal record. This is a severe injury that this represents, arrest and prosecution. While another, segment of individuals, strictly by virtue of their religion, does not have to follow this. And one could raise an argument of, well, people that are not able to do this religiously should not be subject to that mask requirement. And I don't argue that's not the case. And I explicitly set forth, pretextually to the argument that I do not in any manner assert that the face covering requirement is constitutional, or that I assert that the religious exemption itself is unconstitutional. The issue is simply whether or not the religious exemption as it's applied violates the Arizona Constitution, and it does. So basically, summarizing that argument, the Equal Privileges and Immunity Clause is subject to strict scrutiny, and that is the highest level of scrutiny when looking at the constitutionality of a law. And the Arizona Supreme Court has held repeatedly that equal privileges and immunities is a fundamental right, triggering strict scrutiny. So to survive that strict scrutiny, the state has to show that the statute, or in this case, the the order, the mandate, is necessary to achieve the compelling state interest by the least restrictive means practically available. Mm-hmm. And that is not the case. Furthermore, if there is not a legitimate basis for the classification, in this case, those who have to wear the mask and those who do not because of their religion, if there's not a legitimate basis for this classification, or the classification does not further the goal it was intended to achieve, and this is key, it is unconstitutional. So, based upon that, the objective of the face covering requirement is, supposedly to prevent the spread of COVID-19. I mean, that's the purpose of the face covering requirement. Right. So the religious exemption is irrelevant to the achievement of that objective, and in fact appears to work in the opposite direction. So because of this arbitrary classification between persons who are required to wear a mask and those who are not, and that does not advance a legitimate interest of the state, and in fact actually appears to run directly contrary to their stated legitimate purpose, it's unconstitutional, and that's just how it is. For the same reason, as I just explained, the local mask mandates also violate Article 4, Part 2, Section 19 of the Arizona Constitution, which is the local or special laws clause. That's essentially the same, the same argument for equal privileges and immunities, but it has to do directly with municipalities. And so essentially it prevents municipalities from granting special or exclusive privileges to any individual or group. Mm-hmm. And that's exactly what's happened here with the religious exemption. It's a granting of special or exclusive privileges, i.e. you're not subject to arrest for not wearing a mask. And so for that reason, it violates both of those clauses of the Arizona Constitution, just as to the religious exemption.
And you've cited other cases, right? Other case law.
Yeah, I extensively cite to support these cases. Just on the religious exemption, I cite, I want to say, at least 10 cases. Most of them are Arizona Supreme Court. Some of them are Court of Appeals, but almost all of them are Arizona Supreme Court. So, I mean, my arguments are very, very well supported. There's no plausible justification for the religious exemption in the mask requirement. And like I said, I'm not opposed. I'm not opposed to the religious exemption. That's not something that I'm saying, that is in fact unconstitutional, or that the mask requirement is unconstitutional. But I'm not raising those arguments. The only arguments I'm raising are the ones that I've set forth.
Yeah, but it tears by taking that down and taking that aspect on. It tears away at the mandate. And
exactly.
It's gonna bring more people to your side. I would
exactly.
think, which that's definitely a part of it. Okay, the part two of your argument, the business enforcement provision of the proclamation's face covering requirement is unsupported by Arizona law and is unconstitutional.
Yes, and this one is admittedly. This is a novel track that I'm taking with this, but I mean, this is COVID-19, so almost all legal arguments are going to be taking a novel track because we don't have exact specific case law on this. So you have to sort of, connect the dots and create your support based on other cases that are relevant. And so the business enforcement provision, face covering requirement, requires, and I'll read this verbatim, private businesses and venues shall enforce this proclamation by asking any person failing to comply with the emergency proclamation to leave their premises. Business owners are not liable for members of the public who are in violation of this proclamation and refuse to leave their establishment when asked. So that is the business enforcement provision. And essentially it is basically not only delegating law enforcement, I don't want to say authority, but function to private individuals without any lawful basis. It not only delegates it to them, but it coerces them because they themselves are in violation of the proclamation and are, of the mask requirement portion of the proclamation if they refuse to enforce it. So they themselves can be subject to arrest or prosecution or imprisonment for not enforcing the mask covering provision. So basically, what I've set forth, this is page 15, subsection A. Basically, I'm saying it unlawfully delegates authority to and coerces private parties to perform law enforcement functions. So the basis of the power to arrest or prosecute individuals for not wearing a mask comes from Arizona Revised Statute section 26-317, which holds that any person who violates any provision of this chapter or who knowingly fails or refuses to obey any lawful order or regulation issued as provided in this chapter shall be guilty of a Class 1 misdemeanor. And so when we apply what's called strict construction of the plain language, which is essentially, it means that you have to take the language at face value unless it's ambiguous. And this is Arizona Supreme Court precedent, or Arizona Court of Appeals, State versus Slayton, which holds we look first to the plain language of the statute, then to its context and history. So what I've argued is that applying this strict construction holds that it is a crime for private businesses or venues to refuse or even to unknowingly fail to enforce this provision. Because the very first sentence says any person who violates any provision of this chapter. That portion does not say any person who knowingly violates. So this is what's called a general intent crime. There's no specific intent needed to violate the provision. So the second part says, or who knowingly fails or refuses to obey. So we have two different clauses of this statute: any person who violates or any person who knowingly fails or refuses to obey an order. So this is not, these are not mutually exclusive. Right. So when we apply strict construction, we see that it is a crime for private businesses to refuse to enforce this provision. And so basically what I've argued is that under ARS 26-317, Arizona Revised Statute, that is what sets forth who is allowed to enforce these emergency orders. Title 26 relates to emergency functions. And so ARS 26-317 says, quote, the law enforcing authorities of the state and political subdivisions shall enforce these orders, rules, and regulations issued pursuant to ARS 26-317, which is the statute under which the mask order was issued. So it says right here in the Arizona law that it's the law enforcing authorities, not private businesses. So, we have that right there, which not explicitly, but implicitly says that private businesses do not have any authority to enforce this and, therefore cannot be coerced into doing this. And that's what I argue. I said, it's not, ARS 26-317 does not explicitly prohibit persons other than the law enforcing authorities of the state from enforcing the law. It's implicit in light of numerous other Arizona statutes, which we'll get into. Title 41, Chapter 12, Article 8, creates the Arizona Peace Officers Standards and Training Board, grants them the power and the authority to prescribe minimum qualifications for law enforcement. Private businesses and venues are not subject to AZ post requirements. A law enforcement officer in Arizona law is defined as an individual other than a probationary employee who is certified by the Arizona Peace Officers Standards and Training Board. So that's ARS Section 38, 1101. Private businesses are not law enforcement officers under Arizona law. It goes on, and we look and see Arizona law says, except for agency heads duly elected as required by the Constitution and persons given the authority of a peace officer pursuant to sections whatever, No person may exercise the authority or perform the duties of a peace officer unless he is certified by AZ Post, which is the Peace Officer Standards and Training Board. And that's ARS Section 41-1823. Again, a peace officer is any person vested by law with a duty to maintain public order and make arrests, and includes constables. That's ARS Section 13-105. So private businesses and venues are not peace officers. And while
Makes
Arizona,
sense.
right? I mean, why should they be? And Arizona law does grant certain individuals, certain elected officials, the authority to issue orders to private parties to assist them in law enforcement duties. But this is explicitly delegated only to county sheriffs. And that's ARS Section 11-441. No power under any Arizona statute or the Arizona Constitution grants mayors or political subdivisions any authority to command persons to perform law enforcement functions. So essentially, the mayor and the city have no authority to order private businesses and venues to enforce the face covering requirement. It's non-existent. It doesn't exist. So,
are you aware of any private businesses that have pushed back on this in Flagstaff, at least, I guess, on where in this jurisdiction?
I'm not aware of any. I mean, Flagstaff is kind of I guess you would call it kind of a hippie town. And so I have not heard of anything, and I would be very surprised if I did hear about anything.
Hippies used to be for liberty, right? What happened to that?
Yeah, but you know what? If you scare people, they'll forget all about that pretty quick.
Yeah, that's what this is all about. Fear.
So I mean, I don't wear a mask. I don't wear a mask, and I'm not going to wear a mask. I have been approached by persons who work for businesses telling me that I need to wear a mask, and I say I'm not going to wear a mask, and you just go about my business. So in Flagstaff, that's par for the course. But I would imagine in places like Phoenix, I would have a lot more difficulty in doing that. Just because, I mean, it's a different environment. And so, I'm sorry, go ahead. You were going to say something?
No. Keep going.
Okay. So I'm going to move on to subsection B. And this is of the business enforcement provision. Mm-hmm. And this is really
I should add one thing. I'll probably put this at the beginning, but I will post a link to this so everyone can, if they want to follow along also. So I'll post it on the show notes page.
Perfect.
To the suit.
So page 17, looking at subsection B, this is regarding the business enforcement requirements. And this, I have no problem giving credit where credit is due. There were a number of state attorneys general who issued opinions on mask requirements, on the constitutionality and legality of mask requirements. I believe it was Indiana, Louisiana, and Kansas. I believe it was their attorneys general who set forth the argument that I'm raising here, in that requiring businesses to enforce a face covering requirement subjects them to civil rights liability because they're acting as agents of the state. And so in subsection B, that's exactly what I set forth. Section 1983, Title 42 United States Code provides a federal cause of action for private parties whose constitutional rights are violated by government employees or any other persons acting in the color of state law. And
I thought you wanted to keep federal law out of this.
Well, I'm not raising a claim under 42 USC 1983. I'm only showing that the political subdivisions are subjecting these businesses to this liability. So I can cite to federal law, and I can cite to how this liability under federal law is being created without raising what's called a federal question in this petition. Mm-hmm. So I'm just saying, look, what you're doing subjects these businesses to federal civil rights liability, because it does. So it's been pretty well established by the Supreme Court, U.S. Supreme Court, that Section 1983 creates civil liability not just for government employees, but for other private individuals or entities who are engaged in state actions. And that was Lugar versus Edmondson Oil, U.S. Supreme Court in 1982, which held that for private party civil rights liability, the conduct allegedly causing the deprivation of a constitutional right by a state must be fairly attributable to the state. So as long as this private party's actions are fairly attributable to the state, they're liable under this federal civil rights law. And there's a couple of other cases that I cite that. But essentially, liability for private parties under this federal civil rights law, Section 1983, can be established under 4 different tests. There's the close nexus test, symbiotic relationship test, joint action test, and the public function test. Well, these business enforcement provisions meet 2 of these tests. So the private party state actor close nexus test and the private party state actor public function test. So the private party state actor close nexus test says that a private party can be fairly said to be a state actor where there is a sufficiently close nexus between the state and the challenged action of the private entity so that the action of the latter may fairly be treated as that of the state itself. So essentially it's saying, when you're a private person and you are acting in a close nexus with government, it can be considered that you are acting on behalf of the government itself, thereby creating that liability. So the proclamation orders private businesses and venues to enforce the face covering requirements, and this is imposed under threat of misdemeanor prosecution. So this is not asking these businesses to enforce this. This is demanding that they enforce it under threat of prosecution. That meets the close nexus test of 42 U.S.C. 1983. That's per se liability for these businesses to enforce this because they are being coerced into doing so.
Mm-hmm. Makes sense.
And so we also have the private party state actor public function test, which holds that where the private party, in this case businesses, has been, quote, delegated a power traditionally exclusively reserved to the state, unquote, a private party can be fairly said to be a state actor. That's Terry v. Adams, U.S. Supreme Court, 1953. So the proclamation, the mass covering requirement, explicitly tasks private businesses and venues with the responsibility to enforce the face covering requirement, the violation of which is a Class 1 misdemeanor. So because criminal law enforcement is a power traditionally exclusively reserved to the state, private businesses and venues who enforce the face covering requirement are state actors under 1983 because their actions meet the private party state actor public function test. So this is 2 separate tests that are met by this business requirement to enforce the face covering proclamation. So essentially any business that's enforcing this proclamation in any manner subjects themselves to civil rights liability that they would not have if they were not enforcing it or were not required to enforce it.
Let's take a real quick break here. I want to tell you guys about an awesome libertarian podcast. I know you guys think that Lines of Liberty is the only libertarian podcast out there, and we are great. I mean, it's awesome what we do here at Lines of Liberty, but there's other good ones too. In fact, there's a great one called Good Morning Liberty. It's hosted by our friends, Nate and Charlie. They've taken on the onus of trying to change people's minds of how people view libertarians. And they're doing this by leading with a message of compassion first. They're looking at the way in which policies impact people and using the principles of liberty to provide compassionate solutions. I know it's amazing, right? So much more effective than just typing loudly and screaming to yourself and commenting on Facebook statuses. But they're actually giving you tangible ways to talk to other human beings about how liberty is compassion. Amazing, right? So Nate and Charlie are 2 great guys, like I said. I think I said that at the beginning. They have a background in healthcare. They actually own a healthcare IT company. So at times like this, in times of crisis, that we have in this country right now. A great podcast to tap into to get their perspective. You can check it out 5 days per week. So if you need that daily hit of liberty, please check out Nate and Charlie over at Good Morning Liberty. Of course, you can find it on all the regular pod-catching apps, or you can just go to lol.gmlpodcast.com. Good Morning Liberty. Check it out. Sort of not off topic, on topic, but a question about just how did you gain the researching ability to be able to put this together? Is this just...
I will tell you, and it's kind of a funny story. So in 2016, my ex-wife filed for divorce. And long story short, she was able to afford counsel, very, very highly qualified attorney. And I had none. I had no legal representation whatsoever. I had a 1-year-old son. He was 1 at the time. Mm-hmm. My ex-wife was essentially seeking to completely remove him from my life. And it became a matter of either get really good at law or lose your son. Wow. So from basically February of 2016 until, continuing, but beginning in February of 2016, I just started reading everything I could on family law, Arizona rules of family law procedure, Arizona Supreme Court rulings on family law, appellate court rulings on family law, just anything and everything I can get my hands on, to learn this as best as I could. So long story short, 4 years later, I'm still doing this. This is ongoing. And over the past 4 years, I have spent an average of about 2 to 3 hours every single day just reading law. And it's, I don't watch TV at night. I lay in bed on my phone and read rulings and court opinions and law review articles and whatever I can get my hands on, because this is my child. And so, learning what legal research entails and what a properly pleaded motion looks like, how to form proper claims and arguments, how to raise issues properly. That was just practice. That was just getting in there and doing it, filing the motions, filing petitions, filing notices, responses. It was a matter of here's the knowledge and now you get to try and apply it. So it's been a lot of trial and error over the last several years. But, I've reached a point where, and this is going to sound arrogant, but I'm just, it's a fact to me. I feel like I can successfully litigate against any attorney, in any case that I would bring, because I would not bring a frivolous case. So essentially any lawsuit that I file, I feel absolutely confident that I could prevail against any attorney in the United States at this point. And like I said, it sounds arrogant, but I put myself through fake lawyer law school over the last 4 years. I've had, practice in state court, practice in federal court. And I don't know. It's just something I picked up. It really wasn't that hard, to be honest. It just took time.
I totally can relate to it, not personally, but I can relate to it by previous guests that I've had on the show, many who similar to you, but a little bit different, not fighting for their son or going through a divorce, but being in prison and fighting to get their, to get out of prison, to get their sentence reduced. And just like they had no choice. So,
right, exactly.
And, but the cool thing with, the similarity there is really cool because a lot of those individuals, once they did get out, they continue to advocate for other people and give that same support. And same thing with you. You're personally, going through your divorce, fighting for your son. Now you're turning and using that knowledge to help others. So I think that's just a really cool thing. Seeing the similarity there.
Thank you. I like that comparison. I like it a lot. It's very valid.
Yeah, for
And,
sure.
I would say that, everybody thinks that the law is so hard and that it's the exclusive domain of attorneys. And that's just not the case. I mean, this isn't, not to denigrate, attorneys, but a JD is not a PhD in biochemistry. It's not, it's not having spent 3 years in a lab running experiments and trying to get published and stuff like that. It's not the same. Science is a totally different beast. Anyone who has good reading comprehension and a pretty good memory and the ability to form good rational arguments can learn law. Anyone. It's just a matter of reading it.
It's the reason why we have so many damn lawyers.
Exactly. If it was so hard, we would have way more PhDs in biochemistry than we have attorneys.
Exactly. Okay, so just to get back to this, I guess, did you have one more on part 2, one more section there?
No.
Okay.
I've pretty well established that they're
so moving
these
on
businesses are state actors.
I want to move on to part 3. Part 3.
Oh no, I'm sorry. I did have one more of these businesses, and this is page 20.
Right.
So essentially, in addition to the liability that the business enforcement provision creates for these businesses, it also, the business enforcement provision violates 2 separate clauses of the Arizona Constitution, and that is Article 2, Section 13, equal privileges and immunities, and Article 4, Part 2, Section 19, local or special laws. And the reason it violates these is because private parties who are subject to Section 1983 liability are not entitled to a qualified immunity defense. So unlike a police officer who's enforcing a mask requirement, he is covered by a qualified immunity defense, against civil rights claims. Businesses have no qualified immunity defense. It's not available to private parties. It is only available to governments. So for that reason alone, the business enforcement provision violates equal privileges and immunities because it essentially creates 2 classes of people who enforce this law. Law enforcement officers who have qualified immunity and private persons who do not. So that violates the privileges and immunities clause because it's granting privileges or immunities, qualified immunity, to certain persons for doing something while not doing the same thing to these businesses or these employees. So that violates those 2 separate clauses, equal privileges and immunities, and local and special laws, because these businesses do not have any entitlement to qualified immunity. And I cite a bunch of cases through this.
They're being coerced, the businesses are coerced to remove these individuals from their stores or their premises. And if they were to hurt someone, or
if they push someone, if they grab someone, if, strictly speaking, you have a Fifth Amendment right to remain silent if a business is asking you about a mask or saying, why don't you wear a mask? Because they're a state actor. You at that moment have the right to invoke your Fifth Amendment right to remain silent. So you can literally tell a business, I'm invoking my Fifth Amendment right to remain silent. And that's it. If they start questioning you or do anything, you have a Fifth Amendment claim under 42 USC against them, 42 USC 1983. So it's just, honestly, this business enforcement provision is just wacky. It's absurd. Mm-hmm. I mean, it's completely made up. The authority to do this is non-existent. This is something where the government just said, well, this is what we're going to do, and we don't really care that it's completely illegal.
Well, I mean, I don't know. Maybe the thinking at the time was, well, we're only need to do this for a few months. By the time, nobody will come back and fight this. And then, a year later, here we are. So
that very well might be true. Okay.
So part 3, respondents lack any statutory authority to declare a local emergency or enforce any proclamations based solely upon the COVID-19 pandemic.
Yes, and this is where we really get into the meat of this lawsuit. This is a direct challenge to the statutory authority, not just of the political subdivisions, i.e., cities, towns, counties, but also the governor's authority. And so, basically, a ruling on this by the Supreme Court sets precedent, obviously. But this is a pretty major precedent that I'm trying to set here. And essentially, in this section, I'm arguing that the mayor and the city of Flagstaff are not granted even the authority to declare a local emergency under Arizona law for COVID-19. And so I preface this argument by explaining how courts are required to interpret various statutes. So essentially, courts in Arizona favor a deferential approach to statutory interpretation, giving weight to legislative intent and that prioritizes cohesion between the statutes. And so there's a bunch of cases I cite, I cite a bunch of cases. So essentially, the presumption by courts in Arizona is one of legislative competency, and that is that the legislature was not ignorant of any other statutes or the effect of a new statute on the existing scheme when it enacts a law. And that's State versus Garza Rodriguez, Arizona Supreme Court, 1990, holding that we presume that the legislature knows the existing laws when it enacts or modifies a statute. So I go on and set forth how courts are required to undertake an analysis that begins with the plain meaning of the statute. They're not permitted to explore alternate meanings when the plain language is clear. And that was Arizona Supreme Court, Perini Land and Development Company versus Pima County in 1992, which holds we look first to the language of the provision, for if the constitutional language is clear, judicial construction is neither required nor proper. And that's saying that if the language is clear, the court has no authority to reinterpret the statute. They must go by the exact plain language of the statute if it's clear. And in this case, it is very clear. So the requirements under Arizona law for a declaration of local emergency, and that's what the city of Flagstaff, the mayor, declared. So Arizona defines a local emergency as the existence of conditions of disaster or of extreme peril to the safety of persons or property within the territorial limits of a county, city, or town, which conditions are or are likely to be beyond the control of the services, personnel, equipment, and facilities of such political subdivision. So we're going to compare that to Arizona's definition of a state of emergency. This is how the governor can declare a state of emergency, which sets forth that a state of emergency declared by the governor is defined as the duly proclaimed existence of conditions of disaster or of extreme peril to the safety of persons or property within the state caused by, and it sets forth some conditions, one of which is epidemic. So this is not found in ARS 26301, paragraph 10, which defines what a local emergency is. And this is set forth in ARS 26301, paragraph 15 for a state of emergency. So we have the presence of epidemic in the definition of a state of emergency. We do not have epidemic in the definition of a local emergency. It's not there. So if we look at statutory construction, what courts are required to do, the plain language of these statutes is clearly different. The intent is clearly different. There is no apparent legislative intent in these statutes to grant cities, counties, or towns the authority to declare a state of emergency based on an epidemic, whereas the governor does have such authority. And this is exactly what the statute set forth. Strict construction of the plain meaning clearly holds that cities, counties, and towns cannot declare a local emergency based on an epidemic, or a pandemic in this case. And a pandemic is just a more widespread epidemic.
Right, right.
And so
basically the same thing.
Right. So under Arizona law, a local emergency and a state of emergency are not the same, because epidemic is explicitly provided for as a basis for a declaration by the governor of a state of emergency under ARS Section 26301, paragraph 15, a local emergency as defined under ARS Section 26301, paragraph 10 contains no such provision. So the constitutional language of these statutes is crystal clear. So there's no reason for the court to impose or to interpret a legislative intent that's not there. The legislature, this is the same statute. It's just different paragraphs of the same statute. There's no reason to interpret that the legislature intended to grant cities and towns and counties the authority to declare a state of emergency based on an epidemic, when in the same section, they explicitly grant that authority to the governor, but not these cities. I mean, it's crystal clear. And so if we look to, if we say that even if the city of Flagstaff or the mayor could somehow raise a plausible argument that the plain language of that statute is unclear, the legislative intent in defining state of emergency differently than local emergency can be elucidated by looking to the statute that grants cities emergency powers pursuant to their declaration of local emergency. So we say the cities have now declared a local emergency. Let's look to what their powers are. And that's under ARS Section 26-311. So it says, in addition to the powers granted by any other provision of law or charter, whenever the mayor of an incorporated city or town or the chairman of the board of supervisors for the unincorporated portion of the town of the county shall deem that, this is important, an emergency exists due to fire, conflagration, flood, earthquake, explosion, war, bombing, acts of the enemy, or other natural or man-made calamity or disaster, or by reason of threats or occurrence of riots, routs, affrays, or other acts of civil disobedience which endanger life or property within the city. It goes on. It says, if an emergency is declared pursuant to this section, the mayor shall, during such emergency, govern by proclamation, which is what the mask order is, and shall have the authority to impose all necessary regulations to preserve the peace and order of the city, including but not limited to curfews, ordering closes of business, closing streets, public buildings, calling on law enforcement, etc. So nowhere in there is public health mentioned. Mm-hmm. Nowhere in there do we talk about epidemics, because this was not a power that was intended to be delegated to these political subdivisions, i.e. cities, counties, towns. The legislature never intended cities, counties, and towns to manage epidemic responses. That is clearly a function of the state. That is not a function of the city of Flagstaff. I mean, it might be part of the function of the Coconino County Public Health Department, but the mayor, no. The city, no. They have no lawful authority to enact any orders based on epidemics or public health. I mean, the whole purpose of being able to declare a local emergency is essentially predicated on preserving the peace and order of the city, which is exactly what it says in ARS Section 26311, paragraph B. It doesn't say anything about preventing the spread of disease, mitigating public health crises. Nothing.
Yeah, and I would assume that it's something that when this was written, and probably this is similar in almost all cities, you're thinking short term. You're thinking a very short term emergency, a fire. Maybe you do have some sort of like a riot or something like that where you do have to impose a curfew. But to have something long term lasting months and months, that's absurd.
That's just not a function of city government. Mm-hmm. It's just not. It's not something that they are qualified to manage, and that's not something that they've been granted any authority under Arizona law to manage. If the legislature wants to change this statute, they are free to do so. Someone is free to offer a bill, vote on it, and the governor is free to sign it into law. But as it stands right now, the city of Flagstaff and the mayor have zero authority to manage COVID-19 to include mask requirements. None. It doesn't exist. And so we say, if the legislature had intended for cities and, towns and counties to be granted the power to declare a local emergency and to have the authority to impose all necessary regulation to protect public health, not to preserve peace and order, then these would have been clearly provided for under the definition of local emergency under Arizona law or by explicit mention, and there's none. Public health provisions are found nowhere in Arizona law related to city emergency management or functions. So the correct presumption, based upon the plain language of these statutes, is that the legislature never intended for cities to manage pandemic responses. And it's obvious why. They're not qualified to do so.
Right.
And so now we get into the meat of it and why Governor Ducey is named as a real party in interest. That's Section 4. Respondents lack any lawful authority to create or enforce a face covering requirement. And Subsection A, I'm saying the governor cannot assume a non-existent authority. So the governor's powers during disease epidemics are set forth under ARS Sections 26303 and 36787. So during a state of emergency caused by epidemic or pandemic, the governor, in consultation with the Director of Department of Health Services, may order mandatory medical examinations, ration medicines and vaccines, provide for transportation and medical support, personnel and ill and exposed persons, and provide for procurement of medicines and vaccines. So clearly, Arizona law is granting the governor powers to manage the pandemic. I mean, that's clear. That there's no ambiguity here. However, no part of Arizona law authorizes the governor to issue a face covering requirement. Nothing in these statutes suggests that ordering a face covering requirement is a power granted to the governor, and nor does there exist any sort of generic catch-all granting the governor power to order any other measures, such as a face covering requirement. The powers are very clear under Arizona law, ARS 36787 and 26303. So essentially, what we have is that during a state of emergency, the governor is permitted to empower cities and towns to make, amend, and rescind orders, rules, and regulations necessary for, quote, emergency functions. And that's ARS Section 26307, paragraph A. But there's still no clearly expressed authority to the governor under this section to order a face covering requirement, because this is not a, quote, emergency function. Emergency function is defined under Arizona law, and this is ARS Section 26301, paragraph 5. Emergency function includes warning and communication services, relocation of persons from stricken areas, radiological defense, temporary restoration of utilities, plant protection, transportation, welfare, public works and engineering, search or rescue, health and medical services, law enforcement, firefighting, mass care, resource support, urban search and rescue, etc. Mm-hmm. So emergency functions under Arizona law, under the definition, strict construction, therefore deal with what we would most reasonably characterize as critical infrastructure. In critical infrastructure, I cite 42 U.S. Code, Section 5195C, subsection E. The term critical infrastructure means systems and assets, whether physical or virtual, so vital to the United States that the incapacity or destruction of such systems and assets would have a debilitating impact on security, national economic security, national public health or safety, or any combination of those. So essentially, emergency functions under Arizona law is analogous to critical infrastructure under federal law. And so while one could reasonably argue, maybe not reasonably, but let's say, so face coverings might comprise a small portion of the, quote, health and medical services, quote, emergency functions provided for under ARS Section 26301, paragraph 5. However, we could say the exact same thing for anything even remotely related to health and medical services. Toothbrushes, dander shampoo, breast implants. If we're saying that face coverings are an emergency function, then that means toothbrushes are too, because neither of those are explicitly set forth under Arizona law. Mm-hmm. So if we're reasonably saying face coverings are an emergency function, then we're saying toothbrushes are. We're saying anything tangentially related to health and medical services is an emergency function, and that's nonsense. That's not what Arizona law says.
I gotta be careful. They might try to take that next. The toothbrushes and shampoo.
They could try, and I will sue them. I'll figure out something. And so, Governor's Executive Order 2020-40 purports to delegate this imaginary authority to order face covering requirements to municipalities, cities, counties, towns. So it states that Executive Order 2020-40, a county, city, or town may, based on conditions in its jurisdiction, adopt policies regarding the wearing of face coverings in public for the purpose of mitigating the spread of COVID-19. And that authority in that executive order to do that is cited, Governor cites ARS Section 26307. So he cites that as his authority to grant cities, counties, and towns the authority to order face covering requirements. However, the governor himself has no power to order a statewide face covering requirement. Nowhere under Arizona law sets forth that he's able to. It's not an emergency function. So he can't delegate that authority to cities, counties, and towns because his authority to do so doesn't even exist. So essentially, to the heart of the matter, to conclude, the face covering requirement of the mayor and city of Flagstaff exists in the complete absence of any lawful authority granted by the legislature or constitution to enact such a mandate. It is void. It is not enforceable, and it's made up. It's imaginary.
So you filed this on January 6th.
Yes, I filed it by mail.
Any idea what to expect on a timeline? How things would move?
Well, I'm gonna be filing. So I'm right now attempting to get respondents to waive service. Essentially, that means that we don't do formal service with a sheriff. I just send them a copy of the complaint and a waiver, and they sign the waiver and send it back to me, and I file it with the court. So I'm trying to get them to waive service, but I will also either late, well, it won't be this week, but next week I will be filing a motion to expedite proceedings with the Supreme Court. I want to cut down all of the normal timelines under Arizona rules of civil procedure for filing responses, et cetera.
What's their normal timeline?
So their normal timeline, if I had formal service effected on them under Rule 4, Arizona Rules of Civil Procedure, would be they would have 21 days to file a response. And if they waive formal service of the petition, which I'm asking them to do, they will have 60 days to file a response. So what I'm going to be doing is filing a motion to expedite these proceedings. I'm going to ask for, an expedited briefing schedule, assuming they accept jurisdiction. But I'm going to ask for, expedited deadlines. I think, 7 days, 10 days to file a response. This is a pretty straightforward petition that I filed. And I don't see any reason why they would need 21 to 60 days to file a response.
Mm-hmm. Yeah, I agree. So for my listeners out there who, heard this and they want to help you, is there any way that they can help you?
I mean, if they're members of the bar in Arizona, then absolutely. I will take any help that I can get. I never wanted to proceed on this by myself. This was, always something that I have sought legal help for, without success. But I did have a GoFundMe for my old lawsuit that I believe is still up. Because this is not cheap to do this. There's filing fees, there's duplication fees. this is not something that it's just like, well, I've got nothing better to do.
Also your time.
This.
I mean, your time has value.
Tremendous amount of time. People, it's like, I worked on this almost nonstop until it was filed. I started working on the morning of January 1st. And aside from one day when I took a break from it, I've worked continuously to try to get it filed as quickly as possible. Mm-hmm. And so it looks like I do. My my GoFundMe is still up from my original lawsuit against the governor. Let's see. I don't know. Am I allowed to share the GoFundMe link or?
Yeah, you can share the link, and then I'll put it on the website too.
Okay. It's GoFundMe.com/F a COVID-19 federal civil rights lawsuit. And there's dashes between all of that. Or you could Google GoFundMe Joseph McGhee. It's the first one that pops up. Obviously I would appreciate any support of any kind from any individual or group that would help move this lawsuit along. Legal assistance, donations for me to cover filing fees and stuff like that. That would be great. Honestly, that'd be great. Or, if a highly esteemed civil rights attorney wants to file an amicus brief on my behalf, that would be awesome as well. Or really anybody, anybody that wants to get involved and could help move this forward and help get a win, I'll take it. I'm not, this is not my ego on the line. I'm just trying to, I'm trying to fight a noble fight here.
Yeah. And we're at a position in this country that we honestly need people like yourself. You've stepped up and you're taking this on. So you've stepped up, you're leading the way. So I would just ask my listeners out there to, whatever you can to help them out. Because I know a lot of you, a lot of my audience, they're very staunchly against the lockdowns, against the mandatory mask wearing. So if you have an extra $5, $10, whatever you have, I will put it on the show notes page. And also you can just go directly to GoFundMe and search Joe McGhee. That's McGhee, McGhee. And check it out. So anything else you want to plug or talk about, Joe, before I let you go?
Not that I can think of, not without exposing too much of who I am. But I would just really encourage everyone to don't be afraid to research yourself. Don't be afraid to look stuff up. Don't be afraid to try to learn the law. It's really not that complicated. Study rules of procedure. Don't be afraid to bring a lawsuit, by yourself. Everybody who is, in support of freedom and liberty, everybody's got to do something. And if that's learning law and filing a lawsuit and being, a thorn in the side of authoritarianism, then do it. You might win, you might lose, but it's doing something. It handicaps them in some way. If you believe in this, then you got to fight for it, because now is the time. It's, 6 months, a year, 2 years, 5 years. We don't know how long this is going to go on, and we don't know what's going to happen. You got to fight right now. Yeah.
And that's a great point. You might, you might lose, or you might, mess up filing your first lawsuit, but even if you do lose, you've learned something. You've taken steps forward. So
exactly.
Yeah, I love that. All right. Well, Joseph McGhee, thanks for coming on the show.
Thank you. Great to finally tell this story. This has been a lot of work.
I can tell. Hope you all enjoyed that interview on Finding Freedom. Another awesome guest. And hopefully you guys also have subscribed to the Lions of Liberty podcast, and you're getting all 3 of our unique shows in your little listening device delivered to your ears. If you haven't, please do that. Just go to your app, you know how to do it, and subscribe. You can also leave us a 5-star review and a nice comment. We would prefer if you did it on Apple Podcasts, but anywhere you can on the internet, please leave us a positive comment. Also, the 3 shows that we have, Monday's show with Mark Clare, our flagship program, our longest running program, and on Wednesday, Electric Liberty Land with Brian McWilliams. Those guys have been killing it, and I am so excited about the direction of Lions of Liberty. We're seeing some awesome numbers right now, and we're going to continue to grow, so it's great stuff. If you want to support us, we would love that too. Please go to patreon.com/Lions of Liberty. You can support us for as little as a couple bucks, or if you get in at a higher level, you get merchandise and access to us, and all the way up to you can advertise on the show or get to even produce a show. So check it all out, patreon.com/Lions of Liberty. And if you haven't checked it out yet, please consider checking out the Lions of Liberty store, where we have some awesome t-shirts. We have a Taxation is Death t-shirt with an awesome design. We have a Wax On, Tax Off t-shirt. And we're always coming up with new ideas and adding new t-shirt designs to the store. Check that out at lionsofliberty.store. And if you're in the Pride, you get a discount on anything you buy in the store. So you do both of those things and you win. That's all I got, everyone. Thank you so much for listening to today's episode. This is John Odermatt signing off. Always remember to keep your head up and the fires of liberty burning.